matter of Reader versus Ipsa. Are the plaintiffs ready?
We are, Your Honor.
The defense ready?
Yes, Your Honor.
Counsel, please state your appearances for the record.
I'm Josh Sumner. I represent the plaintiff, Mead R. Reader, along with
Cassandra Ludwig.
Thank you.
Brandon Barneau for Robert Race Ipsa.
And John Roosevelt for the defendant, Robert Race Ipsa.
Thank you. Plaintiff, prepare with an opening statement.
We are, Your Honor.
You may proceed whenever you're ready.
Thank you, Your Honor. May it please the court, opposing counsel. Your Honor, this is a case about disregard for other safety and how it damaged Mead Reader's life. That is because on June 6, 2010, Mead, while performing her duties as a meter reader for the City of Columbia's Department of Water and Light, she was attacked and mauled by the defendant's dog, an animal that had attacked others on previous occasions. Your Honor, Mead R. Reader, your plaintiff in this case, a lifelong Columbia resident, a longtime employee of Columbia Power and Light, where she's worked for years helping to support herself and her 4 children along with her husband. Before June 6, 2010, Mead was a completely healthy woman. She was physically active. She enjoyed playing tennis and running and doing her fair share of work around the house. Never did she have any problems with pain in her legs or with any problems with mobility. But all this changed on June 6 of 2010. During the course of her duties as a meter reader for the City of Columbia, Mead would walk among the various residential neighborhoods, such as the Glenwood neighborhood pictured here, go from house to house and read the meters at each house. And along the way, she would meet many residents along the way, a part of her job that she enjoyed very much. Now, at 1113 South Glenwood, the defendant's residence, she knew there were two dogs located there. She paid attention to this sort of thing because Columbia City Ordinance directs meter readers and other city employees, like Mead, to be aware of potentially dangerous elements along their routes. An example of such a dangerous element would be dangerous animals, like dogs. She knew of 2 dogs at 1113. The first dog was Queenie here, a gentle English setter. The other was this dog, Chowser, a potentially dangerous Chinese chow dog.
Objection, Your Honor. That's argument.
I'm going to allow him to continue.
This Chinese chow dog, Chowser. Mead knew this dog to be was potentially dangerous, and she feared it because there was a bad dog sign posted in the front yard in a large tree. And she also knew from her experience of working on this route for some time that the fence gate toward the backyard at 1113 would always be closed, and the dog would come out and stare and growl at her and other passersby from inside the gate. In her experience, the homeowners were also never home when the dogs were out, so she'd just have to come back later because she couldn't safely, in her opinion, go into the backyard to read the meter without someone there to help keep the dogs at bay. Conversely, when the dogs were home, the dogs were never out. So she was always able to safely...
Objection, Your Honor. None of this is... There's been no testimony on any of these facts.
I presume you're going to produce evidence to support what you're saying?
Yes, Your Honor.
Go ahead.
In her experience, the dogs were never out when the homeowners were home and when the gate was open. So she was always able to safely read the meter without any undue delay. But all of this was different on June 6th of 2010. The gate was open, and there was a car in the driveway, which indicated, based off of Mead's experience, 2 things. First, the homeowners were home, and second, it indicated that the dogs were not in the backyard. However, just wanting to be prudent and being cognizant of her duty under Columbia ordinances, she rang the bell anyway. Since there was no answer, and she heard the shower running, indicating that it might be some time before anyone came to the door, and also believing, as I said from her experience, that no dogs would be in the backyard, she went around back and read the meter. That's when, just after reading the meter, she heard a growl from behind her. And she turned around to see, much to her surprise, this dog growling and baring its teeth at her. Terrified, she ran back out through the gate into the side yard, and just as she reached the front of the side yard, she was unfortunately taken down by this dog, and she was mauled for a period of time before finally someone was able to to bring the dog off of her body. Mead was left hysterical and badly cut and scratched up her back, rear end, and legs. These injuries required nearly a week in the hospital and nearly 2 weeks of bed rest at home in order to recuperate from them. The most lasting of the injuries was a deep cut in her right leg that has left a large scar and prevents Mead from running, playing tennis, and continuing on as a meter reader. And unfortunately, she now walks with a limp. She now has to work a desk job where she can no longer enjoy being outside and meeting with her customers along the way, a part of her meter reader job that she used to enjoy a great deal. She has also suffered $48,503 of medical expenses to date and $2,500 in lost wages. Your Honor, during our case in chief today, we will hear from Mr. Westminster. He will tell you how the mail delivery ceased to his house for several weeks in 2004 after the USPS became convinced that the dog in question here, in this case, had dangerous propensities. You will also hear how Westminster became convinced that the dog was a potential menace after a 2005 subsequent incident with a neighborhood child. He will tell you how, as a result of these incidents, Minister determined that the dog was too dangerous to keep as his own, and he sold it to the defendant. He will also demonstrate that the defendant was aware of these previous attacks before June of 2010. We will also hear from Mead herself, who will describe the attack itself and how the resulting injuries have affected her life for the worse. Again, you will also notice when she describes the day of the attack that she believed, on the basis of her past experiences and the observations she made that day, namely that the homeowners were home and that the gate was open, that no dogs would be present outside at 11:13. In short, she will demonstrate that she did not believe she was in any danger by going around back and reading the meter that day. In conclusion, Your Honor, the evidence will show that the defendant knew of the animal's previous attacks on people, yet he insisted on continuing to harbor this animal. The danger the dog posed, unfortunately, was realized when the animal attacked Mead on June 6th. Therefore, we will ask for just compensation for her medical expenses, suffering, mental anguish, and decreased ability to enjoy a healthy, normal life. We will also ask this court to award an additional amount of punitive damages in a sum you believe will serve to punish the defendant and, importantly, to deter similar conduct in the future. Thank you, Your Honor.
Thank you, Counselor.
Could you take it down, though? You mind taking it down?
Oh, sorry about that.
Are you ready, Counsel?
Your Honor, the defense would like to reserve our opening statement until after the plaintiff's case in chief.
Or if you could give your opening statement at the beginning of trial.
Very well.
If you need a minute to prepare because you weren't expecting this result, that's fine.
No, Your Honor, I can. May it please the Court. Your Honor, as you are already well aware, this case is about an unfortunate accident. An accident that did not have to happen. An accident that the evidence will show my client could not have predicted. Now, you will see evidence concerning the plaintiff's injuries. Injuries that my client sincerely wishes had never been sustained. But the unfortunate facts of this situation will show that the plaintiff's injuries are due in large part to her own negligence. There are two main issues in this case. The first, did Chowser have dangerous propensities that Mr. Ipsa should have recognized? And second, did the plaintiff herself act completely reasonably on that day, June 6, 2010? We believe that the evidence will show that both of these questions must be answered in the negative. And thus, at the close of our case, we will ask you to find against the plaintiff. The evidence will show that Mr. Ipsa had little reason to believe that Chowser may have had dangerous propensities. And it will show that Chowser never acted in an aggressive manner except for when the animal was protecting his home and his owners. Now, you will see evidence today that the plaintiff did not follow a city ordinance designed to protect workers just like her. You will see evidence that she knew that there was a beware of dog sign on my client's property. In fact, she knew that sign had been there for over 3 years. You will see evidence that she did not look into my client's backyard before entering, even though it was surrounded by a chain link fence that she could have easily seen into. You will see evidence that she, in fact, could have walked around that fence and looked in and seen anything and everything in that yard, but chose not to. You will also see that she have failed to avoid a dangerous situation when she saw dogs in the yard and decided not to turn around and walk out at that point. Now, there's going to be much dispute today as to whether or not a certain gate was open or closed that the plaintiff used to enter my client's yard. But what is important is that the plaintiff entered a fenced-in backyard with dogs in it without taking proper precautions, and she was unfortunately bitten as a result of being perceived as an intruder. Now, you're going to hear from 2 witnesses for the defense today. The defendant, Mr. Ipsa, and his fiancée, Ms. Becky Giles. Ms. Giles is going to testify first, and she's going to testify that she stays at Mr. Ipsa's house regularly. She's going to speak about Chowser's demeanor. She's going to tell you that she's very familiar with Chowser and that he's a sweet and loving dog. She'll tell you that she has never once seen Chowser act aggressively or had any reason to fear him. She will testify that she does not believe that Chowser ever displayed dangerous propensities before that day, June 6th. And she's going to testify that Chowser is a loyal guard dog, was a loyal guard dog. And in his absence, her home, their home, has unfortunately been robbed on several occasions. She's also going to talk about the day of the accident. She's going to tell you that she was at Mr. Ipsa's home that day. She's going to tell you that she heard the doorbell ring that day and rushed to go answer it. But when she got to the door, there was no one there. Next, she will tell you that she saw her fiancé rushing down the stairs and out to the backyard where Chowser was unfortunately on what was later found to be the plaintiff. And she will tell you that her fiancé suffered significant injuries that day, rescuing the plaintiff. Ms. Giles will tell you that on the day in question, she didn't spray off the pool. She will tell you that she was watching soap operas in the living room all afternoon. She will also tell you that she did not open the gate that the plaintiff went through. She will note that Mr. Ipsa and his roommate Wes always stress that it is extremely important to keep that gate closed, and they almost always do so. Next, Mr. Ipsa himself will get a chance to speak. He will corroborate Ms. Giles' testimony. He's going to tell you that he owned that dog, but that it was previously owned by Westminster. He would tell you that they hung a beware of dog sign in their yard that was clearly visible from the front in any way you approached the house. He would tell you that the purpose of that beware of dog sign was to keep trespassers out. He will tell you that Chowser had not been involved in any sort of incident for the 5 years preceding the one in question. In fact, he will tell you that in the dog's entire lifetime, the dog had never been in any incident except when protecting his home and their owner and its owners. He will tell you that there are only 2 possible times that the dog's actions could even be seen as aggressive. You'll hear that one of those incidents involved a mailman who may or may not have tried to open the screen door to put a package inside. You will hear that Chowser scared the mailman, but he didn't bite him. And finally, you will hear that Chowser was nothing but a little playful puppy at that time. The other incident you'll hear about occurred on Halloween 2005, almost 5 years ago. You'll hear that Chowser hid in the garage that day because he was frightened by all the people in their costumes. You'll hear that Chowser did protect his territory on that day, and he did chase down a delinquent and bring him down, a delinquent that tried to egg Mr. Ipsa's home. You'll hear that although there were many people on the street that Halloween night trick-or-treating, the only one Chowser was aggressive towards was this intruder. Robert Ipsa will tell you that he did not have any reason to believe that Chowser had vicious tendencies before June 6, 2010. Now, you'll hear that the plaintiff went through a gate on the north side of Mr. Ipsa's house to get into his backyard. Mr. Ipsa is going to tell you that that gate was closed when he went to work that morning. And he'll tell you that that gate was most likely closed that afternoon, because when he got home, his dogs didn't come out to greet him. They didn't rush through any open gate to come out as his car pulled up. Mr. Ipsa will tell you that once this unfortunate incident occurred, he did not hesitate 1 second to come to the aid of the plaintiff. He will tell you that he was injured himself in saving the plaintiff, and that his injuries were extensive. Despite his injuries, though, he will again tell you that he had never had any reason to believe that Chowser was dangerous before this. And last, he will tell you that in his mind, the plaintiff's injuries could have easily been avoided had she acted prudently in this situation. Now, at the close of this case, Your Honor, we're going to ask that you recognize this man's right to protect his family and his property. Recognize that Chowser did not display dangerous tendencies to my client. Recognize that even if the dog had done so, Mr. Ipsa took steps, including hanging a sign on the tree and fencing in his backyard, to avoid any possible danger for non-trespassers. Recognize that the plaintiff herself was contributorily negligent. Recognize that, sadly, her injuries are due in large part to her own unfortunate actions. Recognize that the plaintiff has the burden of proof in this case, and recognize that, in our opinion, they will ultimately fail to carry that burden. At the close of our case, we will ask you to please find for the defendant. Thank you, Your Honor.
Thank you, counsel. The plaintiff may call the first witness.
Your Honor, the plaintiff calls Meade Reeder to the stand.
Reader, please come forward. Stand in the witness box. Ma'am, the testimony you're about to give in this court, the truth, the whole truth, and nothing but the truth?
It is.
Please be seated. Please state your name for the record.
My name is Meade R. Reeder.
Thank
Go
you.
ahead, counsel.
Thank you, Your Honor. Meade, where do you work for a living?
I work in the building department at the Columbia Power and Light Department.
Were you employed in that capacity in June of 2010?
I was not. In June of last year, I was actually a meter reader.
And why did you change jobs?
Well, after the attack, I sort of had to change jobs. I tried to go back to being a meter reader, and I would have panic attacks and anxiety attacks because I was so afraid that what happened to me last June would happen again.
And which job, the meter reader job or your current billing position, were you more satisfied with?
I was definitely more satisfied as a meter reader. It was so nice to be able to get outdoors, to talk with people that, some of the homeowners, and meet different people.
Now, do you know the defendant's address?
I do. I think it's 1113 Glenwood, South Glenwood.
And where did this dog attack occur?
It occurred at 1113 South Glenwood.
Do you know how many dogs are kept at that address?
Yes, there are 2 dogs there.
And how would you describe those 2 dogs?
Well, there's one dog, Queenie, and she's such a sweet dog. She's so great. So sometimes I would even just stop by there and on my route to read meters and just say hi to her. And then there was Chowser, who was an awful dog. He was so mean, and he was just a horrible dog.
Would you recognize both of these dogs if you were to see a picture of them?
Of course.
Your Honor, may I approach the witness with Joint Exhibit Number 1, which has been
That's
stipulated?
fine.
And may I also concurrently publish it onto the screen up here?
I'd like to see it first.
Oh, yes, of course. Here you are.
That's fine.
Your Honor.
Thank you.
Ms. Reeder, what does that picture show?
Well, that's a picture of Queenie.
And would you have anything to worry about walking into the yard with Queenie?
Oh, absolutely not. Like I said, Queenie was a delightful dog. She's so sweet and loving.
Your Honor, permission to approach with Joint Exhibit 2.
If there's no objection.
I'd like to see it again, but no.
It's fine, you can go ahead.
Would you like a copy?
Yeah, please.
And permission to display it on the projector as well?
Yeah. Anything you're showing the witness, you can show.
All right. Thank you, Your Honor. Now, How would you describe this dog here?
Well, this is a horrible dog, Chowser. He was so awful and mean and vicious. And if I would be walking by the house, or both dogs would maybe, be out in the backyard and be at the fence, and Queenie would be up there and just want to be petted, and Chowser would just be up there growling or staring and not friendly at all.
Now, in your opinion, how large was Chowser?
Chowser was about 100 pounds, and I think he stood about 3.5 feet off the ground.
How long had you worked this route in the Glenwood neighborhood by June of 2010?
By June 2010, I'm not exactly sure how many years. I had worked that route for a long time, though.
All right. Permission to approach with Joint 7. Yes.
Go ahead.
Now, what is Joint 7?
This is a picture of the neighborhood, or a map of the neighborhood where 1113 South Glenwood is located. It's part of my route.
I'm sorry to interrupt. If you could please describe, making reference to the map is useful, how you approached 1113 South Glenwood that day and what you saw as you approached.
Well, after I read the Hemphill meter, which is actually at 1109 South Glenwood, and you can't see it on this map, but it would be north of 1111 South Glenwood. So I left that house and walked towards 1113 South Glenwood. So I was walking south, but I was approaching the house from the north side.
Your Honor, before I forget, plaintiff moves to have joint exhibits 1, 2, and 7 entered in evidence.
Any objection?
They've been stipulated to your honor.
Thank you. Sorry to interrupt you. Which side gate did you refer to that was open?
Well, as I approached from the north, there are actually 2 gates on that side of the house. There is one that goes into the pool area, and that gate was closed. And then there is a gate it's still on the north side of the house, but to the left of that gate that goes into the backyard, and that gate was open.
And why was the fact that this left side gate was wide open so important to you?
Well, like I said, I've been on this route for so many years, and with that house, I've had experience. I know that there are the 2 dogs in back, and so I know that if the gate is open, that the dogs are not out back, and that the dogs are in the house. And also, as I approached the house, there was actually a car in the driveway, and also with my experience at this house, if the homeowners are home, the dogs are never outside. So the fact that the car was in the driveway and the gate was open, I knew the dogs should have been inside.
So, based off your experience doing that route, did you think the dogs were in the backyard?
No.
So, after you approached 1113, as you've described, and saw that the gate was wide open, what did you do next?
Well, even though I know from my experience that if the gate's open and the homeowners are home, that the dogs are not out in the back, I still went ahead and went up to the front door and I rang the doorbell.
And why did you ring the doorbell at 1113 instead of just going around back into the backyard to read the meter, excuse me?
Well, as meter readers, we're instructed to, when there are dogs or animals at the house, to take precautions, and one of those precautions is to go ahead and go up to the house and knock on the door and have the owners, make sure they restrain the dogs. But within that, we're allowed to use our judgment. And so in this situation, I went up to the house and I rang the doorbell, and I waited for a few minutes for the homeowner to come to the door, and they didn't come to the door, and I heard a shower going, so I had no idea how long that was going to be. And so I went ahead then, based on my other knowledge of how I read the meters at this house, I went ahead and started to go to the back to read the meter.
So, when you ran around to read the meter, did you think that you were doing anything dangerous by going around back to read the meter?
No, not at all.
Did you have any reason to believe that dogs would be back there?
No, I did not.
So, after no one came to the door after you rang the bell, and you went around back, what happened next?
Well, as I came around back and I walked through the gate, I did see Queenie sitting under a tree. She had dug a hole underneath a bush or something, but that really didn't startle me because Queenie is a really loving, friendly dog. So then I just walked up to the meter and started reading the meter. And that was when I had read the meter and I started to make some notes about it. And then that's when I heard the growl behind me and got scared.
You said you were scared. What happened next?
Well, as soon as I heard the growl, I knew that Chowder had to be in the backyard too, and I had not seen him when I first walked into the yard. So I turned around and I tried to just kind of sort of, say, like calm down the Chowder, and he just kept growling and advancing towards me. So I tried to kind of like walk back slowly and go through the gate. So then I did go walk back through that left gate, the open gate sort of ran, I guess, at this point. He's chasing me. And I tried to shut the gate, but the gate got caught on the garden hose, and so then I just was trying to get away from the dog.
And how far did you make it? You said you went through the gate. How far did you make it before the dog reached you?
Not very far out front. If you're looking at the diagram, I had just come through that gate, and I was on the side of the house, on the north side of the house.
And there was a garden. You said what was on the ground?
A garden hose.
And it was stretched through. To help the court understand, where exactly was it stretched through?
Well, it was stretched out from the spigot for the garden hose is at the back side of the house. So the garden hose was attached to that, and it was stretched out towards the other gate that goes into the pool area, because that's a separate area. So the garden hose was stretched out through the gate towards that area.
And what kind of injuries did you sustain as a result of the dog's attack after it took you down the side yard?
Well, he jumped me outside the side of the house, and he was biting at everywhere he could try to bite. So I just tried to curl up in a ball and protect my face. And because he did that, I mean, I had scratches all on my legs and on my back and rear end. And then I have this huge, I had a huge gash at the time. It's now a huge scar on my left knee.
What would you say was the worst of your injuries?
Definitely the scar on my knee. It's awful.
Your Honor, permission to approach the Plaintiff's Exhibit 1.
If there's no objection, it's fine with me.
That's fine. You don't want to object to that? No, that's right. Yeah, you're right. Now the judge can see. We did it.
Take a minute to look at that. What does Plaintiff's Exhibit 1 show?
This is a picture of my knee after it had been stitched up.
Would you say that this photo showing your wound is a fair and accurate representation of the wound you suffered that day?
Yes, it looks yes, it fairly accurately depicts that.
Your Honor, the plaintiff moves for Plaintiff's Exhibit 1 to be entered into evidence.
No objection, Your Honor.
It's admitted.
Thank you. How well did the cuts shown here in Plaintiff's Exhibit 1 heal up?
Well, the cut is completely healed now, but I have a huge scar running over my knee. It's about 4 inches long, and it goes anywhere from it's about a half-inch wide towards the center of it to even, I mean, it's at the thinnest, it's still a 1/4 inch thick.
Your Honor, permission to approach the witness again, Plaintiff's 2.
If they blow it up, it'd be more
Yeah,
prejudicial
fine.
than probative if it's blown up. I thought we always stipulated that they couldn't blow that. Okay.
Now, what does Plaintiff's 2 show?
This shows the Plaintiff's Exhibit 1 is my knee stitched up, but that's right after it happened. This is actually once my knee started healing a little bit. The stitches are still there, but it's my knee as it's healing.
Now, does Plaintiff's Exhibit number 2 accurately show the stitches as they appeared, fairly accurately show the stitches as they appeared as they were healing?
It does.
Your Honor, plaintiff's moved to have.
Submitted.
Thank you. Now, about how long did it take for this to heal up?
It took about a month for it to completely heal up.
Permission to approach the Joint 9.
Fine.
Now, what does this picture show?
This is a picture of my knee after it was completely healed. It shows more of what my knee looks like now.
Now, do the effects of the injuries, the lasting effects of the injuries, which we can see here in the joint exhibit, do they continue to give you any problems to this day?
They do. It's such a large and gruesome looking scar that it's extremely embarrassing. And anytime I try to shave, it just completely makes me relive the whole injury. And then I can't wear anything that shows my knee because I've got this huge, embarrassing looking scar. I mean, it's really awful.
Can you still have any physical activity with it, or does it hinder your physical activity in any manner?
It does hinder my physical activity. I'm limited now in what I can do, and I have a permanent limp on that side of my leg.